Welcome to Channel 17, the Town of Colonie Government Channel.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our legal system, our justice system, and how they intersect with the citizens of the town of Colonie. Today, we are truly blessed to have a practitioner who is involved in so many aspects of the legal field, not only here in the Capital Region, and not only throughout the state of New York, but throughout the entire nation. Our guest today is attorney Jeffrey Selchick, who has been a Colonie resident for nearly 30 years. Its practice has included arbitration, which, as many of us recognize, it plays a very important role in a variety of situations throughout the state of New York. Certainly, arbitrators are called upon to be involved in a variety of contract actions, municipal contract actions, state contract actions, union contract actions, and even actions involving the private sector as well. Our guest today, Jeffrey Selchick, has distinguished himself in a variety of ways throughout our country and is currently has been a member of the American Arbitration Academy. Only 600 practitioners throughout the entire nation serve in that capacity. Our guest today, Jeffrey Selchick, is certainly accomplished in so many ways. He's actively involved in so many of the contract actions that impact our daily lives here in the Capital Region and in the state of New York. Please join me in welcoming Jeffrey Selchick. Judge, thank you for joining us today.
Thank you, Judge. I appreciate being on the show. I've watched it many times, and I've enjoyed it very much.
Well, I can tell you, Judge, that our show today won't begin to do justice to your distinguished professional career, and you've touched on so many variety of issues since graduating from Albany Law School, and then, as I recall, actually working in the governor's office on the second floor. In some labor work at that time, and then eventually becoming to specialize since 1982 in the field of arbitration.
Oh, I was very fortunate, Judge. I was invited to join the Governor's Office of Employee Relations back in 1976, which was an early time of what we call the Taylor Law. So I was involved at a very early stage of the Taylor Law and watched it grow. I served 7 years, ending up as Deputy Counsel and Director of Litigation for that office. And while I did that, I was responsible for the arbitration program for the entire state of New York. In 1982, I decided that I would strike out on my own and become a labor arbitrator. And I've been doing that since 1982. It's hard to believe, but I'm starting my 30th year as a labor arbitrator.
And you've done it not only locally here, whether it's Albany City or Schenectady, but you've also been involved in a number of CSEA contracts, which have statewide ramifications, and also certainly throughout our nation, and most recently spending significant time with police issues in the state of Connecticut as well.
Well, the thing about being a labor arbitrator is it's almost like the old traveling circuit judge of the West. Basically, I travel, and I go wherever the cases are and wherever I'm selected. That's taken me as far as California and as far south as Florida. Of course, I've never had a Florida case in the winter. They only seem to have Florida cases in the summer. But I predominantly now arbitrate for reasons of staying home closer with my children. I arbitrate throughout New York State, including New York City, and as far as Buffalo, Niagara Falls, and Jamestown. And I'm still very active in the state of Connecticut.
Well, Judge, I have to tell you that obviously it's your background and experience as an arbitrator which has impacted all of our lives here in the Capital Region. But I want to tell you on a personal note that I came to meet you while I was a village prosecutor in the village of Menands, and you became an associate village justice And that relationship that I had with you and that mentoring that you provided as a judge certainly was one of the highlights of my professional career. And I'm very lucky to have served in your courtroom at that time.
Well, I appreciate that, Peter. We had a very busy courtroom in Menands, as people would be very surprised. But because we have 787 running through the village of Menands, we would have sometimes 200 to 300 people on a vehicle and traffic night. And we kept you running. I recall that very well. We were both a lot younger then, but it was a good experience. I used to go on the bench at 6 o'clock at night, and sometimes you and I were not out of there till midnight.
Well, there's no question, and of course the court system continues to be challenged in that way as well, and certainly our own court here in Colonie is exceedingly busy. It's a big city court now. Working off essentially a footprint from 50 years ago. And the justice system needs to evolve here as well in the face of the volume. And it's not just the criminal cases, it's also the civil cases, which continue to grow here in the town court. And I know that you noticed that in the Village of Menands court.
Well, in your court now, it's the same process, really, because you have often the case to mediate disputes and try to resolve civil disputes that come before you. So in some ways, you know, we really do the same job. Arbitrators are really private judges. Basically, I'm hired by the parties, who each pay half my fee, by the way, right down to the cup of coffee that I might drink.
Right.
Each of them pay exactly half of every part of the fee so that there is clear impartiality between the parties.
Well, Judge, how do you, arbitration is such a fascinating area, and there's only certain arbitrators throughout our country who have been designated and recognized like you have. You've obviously risen to the very highest level of capacity in this field. And many of our viewers either are members of CSCA or they know people who are, and it seems to me that you're a master arbitrator with the CSCA. What does that mean, and what types of things do you get involved with CSCA?
Well, I'm very privileged since 1994, Peter, to be selected as the master arbitrator. There is only one for the state of New York and CSCA. That means that for all of the New York State CSCA represented employees, if they have a contract grievance, I hear all those cases. And that sometimes involves hearing hundreds of cases affecting thousands of state employees. It's a real privilege and a serious responsibility to be the master arbitrator, and it's one that I have enjoyed very much. I can be involved in almost any type of case that would come between the CSCA employees and the state of New York. So basically, you have to bear in mind that the state of New York, besides being the sovereign, is an employer. And as we've seen in the papers lately, the governor is, if you will, the CEO of that employment company. The CSCA employees are represented, and the CSCA bargains for them, both for their contract terms and conditions, but also represents them in arbitration and contract disputes.
Well, I see that oftentimes you're involved in a variety of different things. You have contract disputes with public sector unions, but I also see that you're often called on to engage and preside in disciplinary hearings, maybe involving police departments or other municipal or government officials as well. Are there different categories of arbitration that you find yourself in?
Yes, basically it could break labor, and I'm a labor arbitrator predominantly, and while I do private sector as well as the public sector, and I do a number of private sector companies in the area, I think what's most interesting to the viewers would be the public sector information. And in the public sector, you really have three types of arbitration. You have contract arbitration, which involves a dispute over a term of a contract. Let's say a fellow who works for the state DOT says that they haven't paid him overtime when he was called in to plow snow and ice. That might be a dispute that I would get. It could be a class action affecting hundreds of those types of employees. And that's contract arbitration. For instance, lately you read a lot about employees in school districts who claiming that they're not being given their proper increments or step increases. That would come to me as a contract arbitrator. But also, all the collective bargaining agreements in the public sector provide for a just cause standard of discipline. That means that an employee who has tenure in the state system and has passed the probationary period can't be disciplined or fired without having a hearing before an impartial arbitrator like myself. This is where the public mostly gets involved when they read about a public employee who's accused of doing something wrong. Maybe it's on-duty misconduct, maybe not performing their job correctly, allegedly stealing, or off-duty misconduct for police and fire and teachers who are held to a standard. So I do a great deal of that. My expertise in discipline extends beyond state employees, and I focused for 30 years on police disciplinary issues. And I probably have done more police discipline throughout the state of New York and Connecticut than any other arbitrator right now.
Well, certainly you've been involved in many celebrated cases over time that we've all read about or heard the names of people that might be part of this disciplinary hearing. Are there any unusual cases or any groundbreaking issues that you developed over, historically that you could share with us about different cases that may be now closed, but certainly either raised issues that were certainly cutting-edge issues, or where the decision had a dramatic impact on the climate involved?
Well, in the disciplinary area, I would say that the most important cases are the ones that affect members of the public generally, and those are the ones that involve teachers and police officers, because we expect much from our teachers and police officers, and when they step out of line, if you will, the public really demands that something be done. And I've had many cases involving teachers accused of sexual misconduct with students, which I think I've taken a very hard line on. When proven, it is my position that people like that have no place in the school system. Again, everything depends on the proof, and what the public doesn't understand is an allegation is not proof. And while the public may read that someone is charged with an offense, that doesn't mean that the offense is proven through the evidence. And you know better than most people that the public doesn't understand that the evidence is what drives our decisions, not our feelings, not what the public thinks, and not what the newspaper has written. You and I, we live and die by the proof that's presented to us. And in most cases, the public doesn't understand, and just like the recent case that they had with this woman with her child, I can't think of the name now, Anthony, Casey Anthony, the public doesn't see the proof that goes in. And the proof in my cases is really what drives the decision. But I've had many cases involving police and off-duty misconduct, which I think have been the most significant in that area. And I think over the years, the standard has gone up dramatically about what we expect from our public employees when they're off-duty, when they're not working and not being paid, but nonetheless acting in their capacity. Remember, you're a judge at all times. When you go to have a bagel in the morning, you're still Judge Crummey, and you're still expected to behave in a certain way. That's a 24/7 responsibility. And that holds true for our police, our teachers, our firefighters, and our other public officials.
Well, it certainly has been kept, certainly the arbitration scope certainly involved in so many of the issues that have involved our community. And what are the potential penalties in a disciplinary hearing that could be meted out? What happens?
Well, we had a law before the advent of the Taylor Law, which came in 1969. We had Section 75 of the Civil Service Law of the state of New York, which provided for a hearing procedure for public employees. That's mostly replaced by collective bargaining agreements, which have now discipline arbitration. And discipline arbitration, when an employee is accused of misconduct and found guilty of such offenses, can range from something as simple as a reprimand or a written warning to a suspension without pay, ranging from as much as 1 day to perhaps 60 days, and to eventual dismissal from employment. Now, dismissal from employment in my world is known as the capital offense. It's capital punishment. What's worse than losing your job? And certainly if you lose a public sector job, the likelihood is you'll never again be employed in a public sector position.
Right. Is the penalty up to you?
Generally it is. I have a
Okay.
great deal of discretion,
Right.
both in finding guilt or innocence of the charges and in assessing a penalty. And that's also very, very difficult sometimes, Judge, because you understand that you have someone's livelihood in your hands. You understand that each person that comes before you is probably not just standing alone, but supports a family and has children and has other responsibilities. So before you make a decision to terminate an employee, you want to be very sure that you're making the right decision. Because what's unusual about arbitration is that unless on the very limited grounds, it's not appealable. So my decision is final and binding. So as I like to tell people, I had better be sure I am right.
Exactly.
Because if I make a mistake, someone is going to suffer the penalty forever.
So you refer to collective bargaining, and of course that's a term that is utilized frequently, certainly in your practice, but it may not be something that all of our residents are aware of. What does that mean, and how does somebody get into a channel where their only redress is arbitration and it's final, as opposed to going into a court system, and then if you don't like that judge's decision, you can appeal that decision and run through the court process, which is available to our citizens. How do these issues get narrowed down to locked into arbitration? How does that work?
Well, it's really by agreement.
Okay.
Collective bargaining really is another way of saying negotiations. And lately, if you've been reading the papers, the state has been engaged heavily in negotiations with its public employee unions. That is collective bargaining. And basically that means that a union that's certified to represent those employees has the power and authority to negotiate terms and conditions of employment on their behalf. Now, the most common term and condition of employment is what you get paid, your salary, and whether you get a salary increase. Your health insurance is a term of a condition of employment, whether you get health insurance and what you might pay for that and what the benefits would be. But also, as part of collective bargaining, there are a number of operational issues that get bargained. In other words, what your hours of work might be, what your schedule might be, who gets selected to get overtime. These are all issues that are part of the bargaining process. And one of them is discipline. And the law, in the Taylor law, has made it clear that while public employees would generally be covered by the civil service law, they can negotiate an alternative procedure through their contracts. And they all do that, because I think that generally arbitration is preferred over the court system, because it is final, and it provides that finality so we don't have to have further appeals.
Why is it in the interest of both the employee and the employer? Obviously, they both think it's better because they've agreed to it in a collective bargaining situation. What's the benefit for the employer?
Well, first of all, I think it's quicker.
Okay.
I think, number one, it's quicker. It's a little bit less formal as well. While we generally don't entertain motion practice, we generally do not have the extensive discovery that you would have in litigation. Also, you select the arbitrator. I'm selected by the parties. So rather than
Right.
in a court system, I mean, when a resident of the town of Colonie has a problem, they will get yourself or one of the other town judges, but they don't have a choice. In arbitration, the union and the management choose the arbitrator. So they can pick an arbitrator that, A, they have confidence in, B, that they know his or her track record, but most importantly, they can pick an arbitrator who has expertise in the field. Because remember, there is no jury. I am the judge and jury on these cases, and so they want to make sure that the arbitrator understands the business. Let's take police, for instance. I probably have done 60 to 70 different police departments in the state of New York, and I've been privileged to do the New York State Police and the Connecticut State Police for over 30 years. They really have a very unique internal system of operations, which they don't want everyone to know. So what happens is when you have a fellow like me who gets acquainted with the system, each case grants me better expertise. I learn more in each case. So by the time you get to where I am, 30 years, I pretty much understand the ins and outs of the various police departments. So that makes me a little bit quicker on the bench as well, because they don't have to explain to me how the A line works or the B line works, or how an officer reports or gets dispatched to a particular scene. So the expertise plays a great deal into it. And of course, this is an experienced business. I'm now looking at 30 years of experience, so I like to think that by this time I've evolved and I've learned something.
Well, we hear about arbitration panels. So and correct me if I'm wrong. So is it a fair analysis that the employer gets to put someone on the panel, the employee gets to put someone on the panel, and collectively the employer and the employee put someone jointly on the panel? Is it a 3-member panel?
No.
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 All right.
All of my work, with the exception of interest arbitration, which we'll talk about perhaps in a few moments, but with the exception of interest arbitration, I sit as a sole arbitrator.
Sole arbitrator.
And the way it works,
Okay.
there's 2 ways you get appointed. One, you could be a permanent arbitrator, as I am for the state and CSEA. That means that they selected me and agreed upon me for the term of their contract. For instance, the last CSEA contract went for a 3-year period. I was appointed for that 3-year period. And I would be the sole arbitrator, and they don't have to select again until the end of that contract.
Did the employer have to agree to your placement too?
Yes,
All
both parties had to agree,
right.
and so they
Fine.
throw back and forth names until they both say, yes, we can agree on Jeff Selchick.
Okay.
The other way I get cases is through the American Arbitration Association, or the Public Employment Relations Board, which governs state and town and municipal labor relations. In that case, the parties, let's say the lawyer for the management and the lawyer for the union, would get a list of 7 arbitrators, and they would each take turns striking one, and the one that's left would get the case. Now, of course, there's a great deal of strategy in this, in how they select and how they strike
Right.
people. And I've been fortunate that I seem to get a great deal of work off that strike
Right.
situation as
Your
well.
name's the only one without a line in it.
Exactly. But the bottom line is they select you. And that really reminds you again of your responsibility, because what they're saying is both sides have confidence that I'm going to be giving them a fair and honest hearing and give them a fair and equitable result, which means that they both have no complaint at the end, whether they win or lose, as to whether or not they had a choice in the selection of the arbitrator. It's a very personal business, which people don't understand. And basically, I do believe that the employers and the unions do research on arbitrators and look at your past record. At this point, I've probably issued 5,000 decisions in 30 years, so there's a big wealth of information out there about me. You can find out how I've ruled on various issues over the years, and I like to think that I'm consistent.
Well, they obviously, they must think so too. If you have joint selection by employers and employees, and they're both asking you to do it, they both must have a comfort level with your capacity and how you've distinguished yourself over the years, and you certainly have. And that's a great credit to you and your profession, and also to the citizens of the town of Colonie, that we call you our own, and you're a son of the town of Colonie, and you have impacted in so many ways positively the length and breadth of our community here in the greater capital region. And it's curious as to your involvement in union contracts. You know, we hear a lot about the state legislature and the governor talking about a 2% tax cap and these different ways that local taxes will be capped so that they can't increase. But it seems to me that actually you could be in a position that, in a decision that you make, that could actually cause a municipality or the state to be forced to go outside of any cap. And how does that, is that really a possibility?
It's a real possibility, and it's what's making my job very, very difficult right now. I also serve as an interest arbitrator, which is probably the most important work I do. An interest arbitrator acts to resolve impasses and disputes for police and fire, only police and fire. The legislature decided many years ago that disputes involving police and fire cannot be allowed to fester. So while some disputes, like in a school district, can go on for years before they're resolved, police and fire, that's not the case. If the police and fire cannot reach an agreement with their employer, it goes to interest arbitration. And that's where the three-member panel comes in.
All right.
That's where I chair a three-member panel, and I'm selected as the public panel member. I not only am the neutral, but I represent the interests of the public. Right. And then each side selects an arbitrator to serve with me. Obviously, someone that espouses the position of the other side. They are not impartial. The union arbitrator wants the union to prevail, and the management arbitrator wants the management to prevail. Now, this allows the panel to decide a dispute for a period of at least 2 years involving terms and conditions of employment for police. So let's take an example. Not so long ago, I did one of our major cities out west in New York along the Thruway, between Syracuse and Buffalo. And not long ago, I did that case in the city of Rochester, and I had to decide what the salaries would be for those police officers. And what's interesting is the city offered, let's say, 2%, and the management and the union perhaps, well, let's get it the other way. The union may have sought a 6% increase, and the city may have offered a 2% increase. And I had the authority to decide what the increase should be after hearing the evidence. Now, let's suppose the city had only budgeted for 2%, and the arbitration panel came in at 4%. The city would have to come up with the money to pay that award, which might mean they'd have to raise taxes, which is kind of interesting when you think of the fact that an unelected official, like myself, has the ability to cause the raising of taxes in a town when no one has voted for me.
Based on the evidence that was presented to you.
Correct, but
Right.
it's a statutory authority.
Exactly.
And it's very important. So now let's get back to the 2% tax cap that was recently enacted by the legislature. Now we have towns and cities and villages and school districts that are saying we have limited capacity to raise more money. So therefore, Mr. Arbitrator, you had better consider that in when you make your award as to what the proper compensation should be for our employees. The most important item in interest arbitration right now is ability to pay. The law says that the panel must consider the municipality's ability to pay. Well, ability to pay and desire to pay are sometimes two different things. But we are now very enmeshed. I have at least 14 current interest arbitrations going on in New York State, ranging from small villages with 10 employees to the correction offices of New York State, which involves 24,000 employees. I'm doing that case as well. And I'm going to have to decide the proper salary and compensation for those 24,000 New York State correction officers. A significant and very important case.
And this will continue too. There's no, I mean, the labor relations and arbitration is a very much part of the fabric of our labor law here in the state of New York and throughout our country. So all of these issues will continue well into the future. And fortunately, you're involved in so many of them in that way.
Well, remember, we're in a very progressive state. The state of New York is, and I'm a lifelong New York State resident, and I'm very proud of being a New York State resident. I love the great state of New York. At times I may not agree with everything it does, but I have to say that I'm a New Yorker through and through. And unlike Wisconsin and other states which have tried to reduce state employee rights and collective bargaining rights, our governor has maintained some tough bargaining, and he's certainly doing some tough negotiating with the unions right now based on the fiscal climate, but there's been no real movement to take away public employees' collective bargaining rights or arbitration rights. Right. And I think that says a great deal about the state of New York, is that we can bargain through tough times without changing the underlying rights that we've given public employees over the years. That's much different than what other states are doing, and I know that public employees are suffering right now, as we're all suffering with the downturn economy, but I think what's important is that we're observing the process. The process continues to go on. While the bargaining may be a little tougher than it's been in past years, the bargaining is still going on. Negotiations are occurring, and as you see recently, agreements are being reached, like they did for CSEA and PEF.
Right.
Now, of course, those still are pending ratification by their membership. We don't know how that's going to turn out yet, but the process is working because negotiations is reaching agreement. Now, in my case, with the interest arbitration for police, fire, and corrections, those parties are not reaching agreement, and they're putting their fates in the hands of the arbitrator.
Right. Well, Jeff, you've been a role model for the practice of arbitration throughout our entire country, and certainly a role model at home as well. 4 fabulous children, no fewer than 2, I believe, are attorneys as we speak. Is that correct? Tell me about the children.
I'm very proud to say that my eldest, Lauren, is deputy county attorney in Schenectady and prosecutes child abuse cases, for which she has a great passion, and I'm extremely proud of her for that.
Absolutely.
And my son has been a lawyer now for 2 years and is practicing in the Capital District in private practice. And my son Brian, who is, I hope someday to get interested in labor relations as well, but right now he's decided to go into private practice. My third child, Karen, is getting her master's at St. Rose and hopefully will be a teacher soon. And my youngest, who's still 17, my youngest daughter, Allison, is going to be a senior at Albany Academy for Girls. So I've raised all 4 kids here. They all went to Loudonville School, which is right down the street,
right. Yeah.
which was about the nicest school you can go to in the Capital District, I would have to say. And they've all attended college locally. The 3 of them have gone to Union College, and my daughter Karen, and Albany Law School, both. So there are 3 Albany Law School graduates in the Selchick family. I'm class of 75. My daughter Lauren is class of 06, and my son Brian is class of 09. And I couldn't be prouder of all 4 of my kids.
Well, and we all are. They've touched our community in so many ways, and it's no wonder. We've been so fortunate today to be joined by Judge Jeffrey Selchick, who is an internationally known arbitrator and who is a resident of our town of Colonie. And thank you, Judge Selchick, for being with us today. I'm Judge Peter Crummey, and thank you for joining me on Benchmark.